They're supposed to be determining what is fair market value. So if they say, hey, your fair market value is only 800,000, but you've got a school that is willing to pay $1.2 million. Well, who the hell are you to tell me that I can't make that $1.2 million? That school's willing to pay me $1.2 million. They're willing to do it. Supreme Court basically says, we do not like you guys restricting how much compensation athletes get. And I know that NIL Go is supposed to be moderating and saying whether or not a deal is fair market value, but who are you to tell these athletes? I'm guaranteeing you, you're going to see lawsuits for the first time they reject it. Today, we are talking about House v. NCAA settlement. I know that for a lot of people, this is kind of old news. It's a week old, but I wanted to go ahead and read up on everything that's happening with regards to this. What we're going to do is we're going to start off with the SI because we need to understand. I think it's important to understand what this all is, the House v. NCAA settlement and all those sorts of things. We're going to start off with the Sports Illustrated article. So let me go ahead and switch screens for you guys so you can see what it is right here. So college athletes are getting paid. Here's what to know. Let's go ahead and just get right into it. Last Friday night, as we know now, a settlement was approved. It was approved by U.S. District Judge Claudia Wilkin. And you guys have to understand, Claudia Wilkin, she is the judge that took care of the O'Bannon v. NCAA judgment. So she is very favorable to anybody who's suing the NCAA. That's why the plaintiffs went to this particular court, because they knew they were probably going to win. And obviously the NCAA was very freaked out because she would vote against them. She would rule against them. So now, because of this lawsuit, student athletes are going to be getting paid directly from the university. So let's go ahead and talk about how we got here. And if you guys can't see it, I'll go ahead and read so you guys can kind of get that idea. In 2020, Arizona State Sun Devils swimmer Grant House became the lead plaintiff in a lawsuit challenging the NCAA's rules surrounding name, image, and likeness. So this isn't the U.S. House of Representatives. This is a person by the name of Grant House. An injunction was issued that would allow for the sharing of broadcast revenue that was received by the various conferences. This antitrust case eventually wound its way through the court before a settlement that was announced between the associated parties in 2024, and then it was finally approved of in June. Just to give you guys an idea, it took a while for this to really finally be fully officially done. They had reached this agreement like back in 2024, but there were some disputes about who this was going to, who all the money was going to be going to. Also some disputes because we have the new roster limits that are coming out. What was going to happen to some of the players or some of the athletes on rosters right now? Were they going to get kicked off? Things like that. So what you really had was you had these people basically going through this, and now that's been approved. In addition to millions of dollars in damages related to back pay of NIL rights for athletes so far back as 2016, the $2.8 billion settlement also calls for revenue sharing directly with athletes for the first time. Okay, so this agreement, it covers the next 10 years. So this is basically a 10-year program. It can continue to grow in terms of how much can be paid and distributed to student athletes at a school year after year after year. They're saying it could get up to like $32 million, but we're starting off with just this first year at $20.5 million, as I understand it. Yeah, and it's down below. Okay. So what can schools pay athletes now? I just mentioned it, $20.5 million. They're permitted to share up to that much with athletes each year, and that's all the athletes in the school. Now, to understand that, how that money is divided up, that lies specifically with the schools. Here's the thing to understand. It doesn't make every school be a part of this. They all don't have to do this revenue, basically, giving revenue with the athletes. You have to opt in. All the Power 5 conferences, the bigger conferences, they've all decided to opt in on this, but not all schools have to opt in with this. They can decide not to. Obviously, there's a lot of schools that are like, well, we're going to fall behind if we do that. So you don't want to have that happening. You want to be able to go ahead and get in and be a part of it. How this is going to be divvied up, it lies with the school, but most are expected to follow a similar formula as the back damages payout, with 75% of the money being directed towards football, 15% to men's basketball players. So right there, you have 90% of the money of that 20.5 million is going to two sports, the moneymaker sports, football and men's basketball. That is a big deal, right? Because they're the ones who make all the money for the school. So they're the ones who are going to go ahead and get the most money from these payouts. 5% is going to go to women's basketball players, and then 5% goes back to the remaining players of all the other sports in the school. So that kind of gives you an idea. What is 5% of 20.5 million? Well, let's take a look. Let me go ahead and calculate it on my phone right now while we're doing it. 20.5 million times 5% is $1 million, $1,025,000. That's going to be spread out and divided amongst all the rest of the school, all the rest of the student athletes, quote unquote, student athletes in the school. So if you're a track runner, if you're a swimmer, all that, you're going to get way less money than anything than that. So that's how it's currently been set up with regards to all of this for this program. Again, not all schools have to do it, but they have to opt in, and so that's what's been set up with regards to that. We've talked a little bit about individual sports, but we haven't said exact percentages. ACC Commissioner Jim Phillips said, I know for all 5 of us power conferences, no one is forgetting about their Olympic sports and continuing to make sure that we invest at a high level for all our sports. So that's kind of interesting. The back pay is going to be divided up 75%, 15%, 5%, and then 5%. Schools might decide, hey, we're going to do 60% to football, maybe 50% to football, 15% to men's basketball, and then that gives us 35% for all the rest of our student athletes. That they could decide to do that. That, again, who knows? It's up to the schools how they wanted to divvy this up. So even within those tiers, the money is expected to vary. Wiley, with the star quarterback, naturally expected to make many more times than the school hands out to the 6th man on the basketball team. It's just basically, it's going to be up to the school. So it's up to each school individually how they want to divide that $20.5 million. So that's the first part of the settlement, okay? This is where you get this settlement with the House, with Grant House. Hey, we're going to give back pay to all the athletes that were a part of this school, that played in athletics, that were part of the NCAA athletics program. You guys are going to get back, so Joe Burrow's going to get a check. Just so you guys know, like Joe Burrow will get a check for having played for the in NCAA, right? Jamar Chase, guys that just barely got drafted, within the last few years that weren't a part when NIL was legal so that they could make money off their name, image, and likeness. They're going to get some money from the NCAA in this regard. So that's the first part of it. The second part of it, and let's go ahead and go through right here. What else happens as a result of the settlement? Perhaps the most tangible aspects to the settlement is the arrival of roster limits. So you might have heard that, hey, we're doing away with walk-ons. Walk-ons are no longer going to be a part of football, which is kind of sad because walk-ons always are a great story with regards to football. That's one of the things that really kind of gives people hope. Hey, you can get a walk-on. It's also been abused by a lot of schools where they'll go, we'll give you a preferred walk-on. We'll do a preferred walk-on for you at this school, and then we'll help you out. It's been kind of abused. This is going away. While in the past, schools were capped in terms of the number of scholarships they handed out for a particular sport. For example, football being at the FBS level 85 for the past several decades. That will soon be replaced by a hard ceiling in terms of the number of players they have on a team. So again, you would do like, hey, we'll help you out. We're only going to do 85 scholarships. We can only have 85 scholarship players. But you come be a preferred walk-on player for us. Hey, we'll give you a little bit of a deal. Maybe we, help you out a little bit right here. That happens. That was what was happening. So teams would have, hey, we'll have these rosters, huge rosters. Well, that's kind of going away, right? We're going to have a hard limit on the number of players you have on a team. So this can result in some sports seeing more players involved and the option of receiving full scholarships instead of partial ones. So you could have guys getting some partial scholarships instead of, getting the full scholarship instead of the partial one. That's a good thing, I think, especially in some sports, because in some sports they only give partial, even at the Division I FBS level. but there's also probably going to be a reduction in certain spots. There's only been a handful of power conference schools that have announced plans to fully expand their rosters to include the maximum amount of scholarships handed out. Again, big deal. As many of these schools, and it's going to affect the non-money making sports, football, men's basketball. I don't think you're going to see issues with that, but you might see that with other sports where they're like, hey, we can't do anything to help you out, and we're going to have to cut spots. So that can be a part of the problem here with regards to that. It's up to the schools to do that. Most major universities plan to expand their athletic offers in some form or another starting as early as this fall. So we'll see what happens. We'll see how this goes. It's very interesting how they put it this way because, again, it could be per sports differently what's going to happen to athletes. But this is a result of the settlement. We're going to have roster limits. The reason that it took so long to get this settlement approved was you were having a lot of people, the plaintiffs that were winning this settlement, that were getting the settlement from the NCAA, they were worried that, hey, people are going to get cut and get cut out for making money because we want to protect those just because of this new incoming roster limit. And so this has all been taken care of. The roster limit situation doesn't apply for those in the past, but it will affect those going forward in college sports. The second thing that really came out of this House v. NCAA settlement is NIL Go. And if you don't know what NIL Go is, it is an attempt by power conferences to regulate the name, image, and likeness marketplace. Many people keep talking about how it's out of control in name, image, and likeness. It is basically pay for play, guys. Just so you guys understand, it is a pay for play scheme. That is what it is. That's what it's been, because there were no rules governing it. There was no governance of it overall. And so the NCAA didn't have anything that they could do. And just give me a second right here. This is where you have a problem with regards to that. Sorry. So NIL, this is an attempt to regulate it because what you were having was people were just being paid to come to school, right? They were getting money, and did you play? No, but you got your money and you're out. And we saw that with the Iamaliava kids, some issues there because there's nothing that could be done. Because again, remember, all the NIL collectives, they're outside of the schools. These are businesses. These are boosters. There's no way for the schools to technically regulate it. And that's partly because the schools didn't want to have it going through the school because then they would have to make the players be employees of theirs. Surprise, didn't want them to be employees of theirs. So if someone's in the chat, by the way, let me know if the stream looks good. In fact, let me just go to my own stream. How about that? But that is, so what we have now is we have an attempt for people to go ahead and regulate this somewhat. So that's the big thing that's going on here. Let's go through the NIL Go. Business in the NIL world is set to change significantly as a result of the settlement, with the current Wild West being replaced by a structured workflow for deals. Players and the schools, which can now also help players get additional NIL deals. The most notable new change is that any deal signed by athletes with a value of over $600, so anything over $600, the details must be sent to a new third-party clearinghouse dubbed NIL Go. It's an entity being run by the accounting firm Deloitte, and it will attempt to regulate the market somewhat by determining whether deals are within a range of the nominal fair market value. So, what is the fair market value? Well, this is what the fair market value is. It's an asset's price that is just right for both the buyer and the seller based on what the asset is worth in the market. So basically, fair market value is, hey, what are the buyer and seller willing, what is the buyer selling it at, and what is the buyer willing to pay for what the seller is selling at, right? So if I go out and I say, hey, as a quarterback, give me $1 million, and schools are willing to pay that $1 million, is that fair market value? Well, yeah. Video games are going to $80. If I'm willing, I might think that that's too expensive, but if people are willing to pay that $80 for that video game, well, then that's the fair market value, okay? And so what's going to be happening is and let's go back to the other screen. What's going to be happening is now you have this accounting firm. They've got to figure out basically, hey, is this really within fair market value? Is it realistically what should be going on with the fair market value of to protect the schools and also the player from, maybe they're getting lowballed on an offer as well, in terms of an NIL offer. Something interesting there, not to think about. That's the thing that's come up now with this NIL Go, and that the whole point of that again is to try to make sure that people are just not doing pay for play. What has occurred is everybody's been concerned is originally name, image, and likeness was for athletes that had shown that, hey, they're doing really well. Like Marcus Mariota goes to school, makes a name for himself. He's going crazy. He wins the Heisman, all those sorts of things. Well, now his name, image, and likeness, people are buying his jersey, things like that. He should get a cut of the profits. He should be able to do commercials, like with Dr. Pepper during games, things like that. That's not what's been happening. People are going, hey, we're going to give you $1 million to do a couple show up a couple times at a place. It was just pay for play. So, for example, and let's continue with the article. Sorry. For example, Heisman Trophy winning quarterback at a team in Los Angeles is going to get a higher end deal than a backup left guard in a Midwestern college town. If anything ranges beyond such limits, such as some of the current deals with school collectives that are paying out millions to some players, those are supposed to get flagged by the system. Players can then either alter their payouts or structure of the deal or take things to arbitration in order to get cleared. If it isn't cleared, they could be suspended from playing. So this is a big deal. Just a big deal, guys. The NCAA is giving up basically compliance rules, monitoring with regards to NIL and payment to players. They're giving that up. Basically, this NIL Go is also going to be the ones kind of basically monitoring the payouts by the schools of that $20.5 million. So what don't we know? Surprisingly, a lot. At the annual gathering of athletic directors and administrators in Orlando, just a few days after the settlement was approved, a constant refrain in the wake of the ruling was that the broader set of athletic departments impacted by the settlement had been planning for it to go ahead for years. While true, there is a difference between game planning and executing a new multi-million-dollar enterprise for the first time in a 25-day span from start to finish. Another quick question that will be fleshed out and publicized. There's the matter of the College Sports Commission. Excuse me, I've said NIL Go. It's the College Sports Commission. I meant to say that. That's a newly formed LLC. It's been set up by the Power Conferences. Remember, I said the Power Conferences are setting this all up to do this, to essentially administer the settlement's finer points. That means that they're going to be ensuring that schools are in compliance with the overall cap. And it's important to understand, people are calling it a salary cap. It's not a salary cap. It's a revenue cap. Salary cap means that these athletes would be employees of the school. They're not going to be employees of the school. So it's a revenue cap is basically what's happening here. But they're going to be making sure the schools are in compliance with the cap to spend on athlete payments, and will also include an oversight function when it comes to third-party deals sent through the NIL Go system. So NIL Go is going to make sure that everything is good and with that fair market value. And that's Deloitte, that's the accounting firm. And then if something happens, then it's actually the College Sports Commission that's going to be the ones doling out the punishment. It includes building up a new enforcement arm, set to be overseen by the newly hired CEO, Brian Seeley, a former MLB executive, who will be tasked with handing out punishments that are supposed to range from fines to suspensions. While there are varying degrees of skepticism, the settlement provides an avenue for a school to see its revenue sharing number decreased. Its head coach is suspended and its players suffer an eligibility hit should any stray beyond the guardrails that are currently set. Okay? All rules with regards for the NCAA in terms of paying players, those are all going to be wiped out as of July 1st, and then all enforcement is going to be handed over to the College Sports Commission. Eligibility of academics, like sign stealing scandal, things like that, well, those will still stay with the NCAA. Anything in terms of monetary payment to the players, that's going to the College Sports Commission and the NIL Go. Right now, football, not going to affect anything going forward for the coming year, but it's going to affect stuff in the coming years. And we're already seeing that. So what's next? It says right here, more lawsuits for one, with the settlement itself likely leading to a slew of incoming cases, including thorny issues such as Title IX and limits on compensation. And guess what? We've already had it. Okay, from Front Office Sports, group of women athletes filed appeal of House versus NCAA settlement approval. They are arguing that the terms of this settlement violate Title IX, the statute governing gender equity in sports. So already, right, from the Sports Illustrated article, we've already saying, hey, there's lawsuits that are coming. Basically, 2 days later, hey, look at this. Well, not 2 days later. Basically, 5 days later, you have a lawsuit already coming in, being done against this particular settlement. So as you saw there, this is a 10-year program. Basically, it's the NCAA trying desperately. They're trying desperately to get everybody off their back. Like, hey, see, we're taking care of the problem. The problem has been we haven't been paying the players. Now we're paying the players, right? We're giving them that compensation, things like that. Who knows? Again, each year they can up the amount that's going to be shared with the players. So who knows what's going to happen at the end of the 10 years. But let's go ahead. Honestly, they're trying to do it to buy time for the House of Representatives to come up or Congress to come up with something. But because they keep trying to get an antitrust exemption, and there's really only one way to do that, and we'll talk about that in just a second. But let's go ahead and take a look at the female athletes filing lawsuit. A group of 8 women filed an appeal of the House versus NCAA settlement approved on Wednesday, arguing that it violates the Title IX gender equity statute. The appeal only challenged the back damages portion of law of the settlement. So it's not so challenging going forward, but it's challenging how much money is being paid in terms of the 5% to women's basketball and then the 5% to the rest of the NCAA athletes. It's the first appeal of the landmark settlement. And okay, so let's go ahead and read what's happening here. The law firm, Black & Cook, which filed the appeal on behalf of athletes, also filed one of many objections to the settlement during its approval process. But now the firm is making another attempt. The 8 athletes are a mix of track, soccer, and volleyball players. And remember, they're all lumped into that 5% that is given to the remaining. After you have basically the 95% going to 3 sports, they're part of the 5% that remain. And so they're basically saying, hey, that the calculation to distribute the $2.8 billion in damages violates Title IX because female athletes would theoretically receive less money than football and men's basketball players in damage payments and revenue sharing. Attorney Ashlyn Harris estimated it deprives female athletes of $1.1 billion. Paying out the money is proposed to be a massive error that caused irreparable harm to women's sports. So that is not signed up with the newspaper. Sorry, Front Office Sports. And so that's what they're trying to argue. Here's what the judge, the woman who has ruled against the NCAA, favorable person to get if you're trying to sue the NCAA. That's who you want on your case. Wilkins said previously that objections related to Title IX did not move her. Her reasoning, the House settlement is an antitrust case, not a gender equity case that has to offer damages and other relief based on the money players would have earned if the rules were different, even if that but-for world wasn't equitable. Wilkins did say in her approval decision, however, that athletes are free to sue on Title IX grounds in the future. So what does that mean? Oh, that means that lawsuits aren't going away. Again, the NCAA, they were trying desperately. They've been trying desperately to not be dealing with lawsuits. I think you're going to start seeing more lawsuits. Hey, and this is where it's going to be important for these schools that are paying out. Are they paying? Are they paying these when their payouts being able to fit within a Title IX? If they aren't, then hey, guess what? You're going to start having lawsuits against potentially individual schools, against the conferences, things like that. So let's go ahead and talk a little bit further. Okay, gone back to the we've gone back to the Sports Illustrated article. Let's talk a little bit about, like I said, remember I said it's not a salary cap, it's a revenue cap. This is from The Athletic. Again, all the links to everything that I'm reading is down below for you guys in the description if you want to take a look at these articles and go over them in a fine-tuned comb it through with a finely tuned I can't remember the word all of a sudden. My brain has broken on that. So they're calling it revenue sharing. But it's calling it revenue sharing because, again, college staff, because of the student athlete situation. But it's revenue that's being shared. So it's revenue being shared. It's a proper term. As you read through it, it's not salary cap. Okay. So here you see this. Why is this called revenue sharing? And who was it that decided salary cap is a dangerous pairing of words that must never be uttered? Was it the NCAA, the courts, Dr. Strange? And the answer, as usual, it's the lawyers. It's helpful to remember that the House settlement was born out of the NCAA and Power Conference attempting to avoid yet another high-profile defeat in court. Remember, they've been losing time after time after time after time. And the financial ruin that would have come with it. Some of this is about progress, sure, but a lot of it is about the top stakeholders in college sports trying to mitigate the onslaught of legal battles in recent years. And it was estimated that if the NCAA lost this case against Grant House, the resulting decision probably would have been $3 to $4 billion to pay out. So they are definitely trying to get ahead of it so that there's no issues with regards to that. It's revenue sharing because the pool of money that can be paid directly from colleges to athletes under the settlement is calculated using the revenue that Power Conference athletic departments generate through television contracts, ticket sales, and sponsorships. The reason it's a revenue cap, remember I said it's a revenue cap, not a salary cap, is because salary would imply that the athletes are being paid for their services or as employees, which remains taboo. Remember, colleges don't want to have these guys called as employees. There's a whole slew of reasons for that. They'd rather they're just students. They're student athletes for us. The settlement has ripped away the facade of amateurism, but the NCAA and Power Conferences still want to classify athletes as students, not as employees. So again, this settlement, it's not a fix-all. It's just a way to try and slow down the lawsuits. And what's going to happen is you're going to have more lawsuits. Okay, you're going to have more lawsuits. One of the problems that I have, and I'm just going to, so now that I've been reading that, let me go ahead and go back to the talking screen. One of the issues, and let me go ahead and hide this actually. One of the issues of this whole decision is, again, you have the College Sports Commission that's supposed to be regulating the payouts that the athletes are going to be getting, and the NIL go. The fair market value decision stuff is going to be interesting because, again, what does fair market value really mean? It means if the buyer is willing to pay what the seller is selling their services for, is that not fair market value? Or are you going to say, hey, or are you going to say, hey, this quarterback is not, you as a quarterback, your fair market value is not the $1 million mark. It's more like the $500,000 mark. This, again, opens up to a lot of issues, and I hate to say it, it's gonna result in lawsuits. And here's where, Stuart Mandel wrote about it again for The Athletic, and here's why. I think a lot of people want. You have to remember, Alston v. Supreme Court. This is the decision that basically allowed athletes to start making money off of their name, image, and likeness. In that decision themselves, and let me actually go right here. Okay, this is the decision with the concurring opinion by Justice Kavanaugh. One of the problems was that the Supreme Court basically was saying, in no other industry do we let companies, and they talk about schools as companies, they don't let companies conspire to either not pay their employees or not pay them at all. So let's go ahead. This is the decision right here. This is the concurring decision by Justice Kavanaugh at the beginning. And so you can see right here let me go ahead and go right here for you guys. The NCAA has restricted the compensation and benefits that student athletes may receive, and with surprising success. Let me make sure, you guys can see that right there. The NCAA has long shielded its compensation rules from ordinary antitrust scrutiny. Today, however, the court holds that the NCAA has violated the antitrust law. So this is from this decision. This is in 2021, guys, and I think this kind of got lost. Everybody was super excited about the NIL, but they missed this part, okay? Basically, it says, let's scroll down to page 43. The NCAA acknowledges that it controls the market for college athletes. The NCAA concedes that its compensation rules set the price of student athlete labor at a below market rate. Very important. Below market rate, right? And the NCAA recognizes that student athletes currently have no meaningful ability to negotiate with the NCAA over the compensation rules. The NCAA nonetheless asserts that its compensation rules are pro-competitive because those rules help define the product of college sports. Specifically, the NCAA says that colleges may decline to play student athletes because the defining feature of college sports, according to the NCAA, is that the student athletes, they're not paid. Okay, so this was the argument being made at the time, 4 years ago. Hey, we don't have to pay them because the point of being student athletes is you aren't paid. Now, I have some things to say. I don't think people really fully understand scholarships when they were created basically in the 50s. That was a way to, in their mind, pay the athletes. Before then, it was like kind of the Wild West, guys, within college sports. But it was decided, hey, we'll do scholarships, athletic scholarships, as a form of payment for athletes. Before that, you had all sorts of things where some schools were paying for vacations of players and things like that. But here's what Justice Kavanaugh says when he says, hey, this is what the NCAA is saying. Hey, we can't pay these people because they're student athletes, so that's why we don't pay them. Like their circular argument. Says this argument is circular and unpersuasive. The NCAA couches its arguments for not paying student athletes in innocuous labels, but the labels cannot disguise the reality. The NCAA's business model would be flatly illegal in any other industry in America. All of the restaurants in a region cannot come together to cut cooks' wages on the theory that, hey, customers prefer to eat food from low-paid cooks or cooks that aren't paid at all. Law firms cannot conspire to cabin lawyers' salaries in the names of providing legal services out of a love of the law. Hospitals cannot agree to cap nurses' income in order to create a pure form of helping the sick. News organizations cannot join forces to curtail pay to reporters to preserve a tradition of public-minded journalism. Movie studios cannot collude to slash benefits to camera crews to kindle a spirit of amateurism in Hollywood. Price-fixing labor is price-fixing labor, and price-fixing labor is ordinarily a textbook antitrust problem because it extinguishes the full free market in which individuals can otherwise obtain fair compensation for their work. All right? The bottom line is that the NCAA and its member colleges are suppressing the pay of student athletes who collectively generate billions of dollars in revenues for colleges each year. Those enormous sums of money flow to seemingly everyone except the student athletes, college presidents, athletic directors, coaches, conference commissioners, and NCAA executives taking 6- and 7-figure salaries. Colleges build new facilities, et cetera, et cetera, et cetera. So, but the student athletes who generate the revenues, many of whom are African American from lower income backgrounds, end up with little or nothing. All right, so everyone agrees that. So it goes through it all. But I want you guys to understand that. Basically, right there, Justice Kavanaugh is outlining what the court is saying. And the court is saying, hey, you cannot come together and say, hey, we're going to prevent you from either getting paid, we're going to make it low paying. And I think this is where we're going to have a problem with the College Sports Commission. And I think this is where it's very important for people to understand this. And I don't think people really pay too good of attention to this portion of it. Stuart Mandel, as I mentioned, he wrote this article. House Settlement Clearinghouse won't create CFB's goal for more level playing field. The rich are going to get richer, guys. OSU, Michigan, Alabama, Texas A&M, all those schools that have Texas, all the schools that have a lot of money, they're going to keep having a lot of money, and they're going to be able to kind of keep paying. They're going to be able to handle that revenue a little bit more. They also probably can get their collectives to do some things a little bit better. I don't see this necessarily helping out the little fellas like the Colorado State, the Boise State. Well, Boise State might be okay, but anybody from the American, I don't. Are they going to opt in? Again, you have to opt in for this opportunity to share that revenue with your athletes. This all remains to be seen, and we've seen how those schools can't keep their athletes because of NIL offers from the bigger schools, those NIL collectives. So how are they going to be able to handle this now that the student athletes, student athletes are being paid directly by the school in those revenue sharing? But one of the things is and this is talked about right here. Reason I say I there's going to be more lawsuits coming is the College Sports Commission. Remember, what's the job of the College Sports Commission and the NIL Go? The Deloitte accountants. They're supposed to be determining what is fair market value. So if they say, hey, your fair market value is only $800,000, but you've got a school that is willing to pay $1.2 million, well, who the hell are you to tell me that I can't make that $1.2 million? That school's willing to pay me $1.2 million. They're willing to do it. It seems a lot like, hey, we've created this commission that's going to be conspiring to potentially take and limit the wages that those student athletes can get. And this is what Stuart Mandel is saying right here. Every legal expert I've spoken with about this subject, okay, excuse me. Let me go up to the part just above it. In every other industry in this country, fair market value is whatever someone is willing to pay you. Just ask the many media. I'm sorry, I messed this up. Let's go up to the paragraph just above this one. Sorry. But where the settlement veers into outright market manipulation is the establishment of a new NIL Go clearinghouse, operated by Deloitte, by which athletes must submit all deals they receive from outside sources that exceed $600, which in every major sport, well, that's pretty much all of them, right? $800, hey, you've got to send this to NIL Go. So Deloitte's going to be making bank because they're going to be charging all this to everybody. Hey, you got to pay us to be doing this accounting. You're going to have a full-time team at this accounting firm just basically monitoring and going over this stuff. Craziness. If Deloitte deems, say, a running back's $1 million deal from a school's collective to be above fair market value, remember, I just said that. Hey, this quarterback, you're really only worth $800,000. They're offering 1.2, but you're only $800,000 worth. He cannot accept it. And in every other industry in this country, fair market value is whatever someone is willing to pay you. Just ask the many mediocre football coaches making $6 to $8 million a year, athletic directors who make $1.2 million a year to hire those mediocre coaches. No clearinghouse for those folks. And this has been part of the problem. This is why you've had these lawsuits. That's why you've had all these things. And this is what it says right here. Every legal expert I've spoken with about this subject thinks there's little chance this clearinghouse would survive a legal challenge. Remember, I just read to you what Justice Kavanaugh said back in 2021. Okay, well, remember, he just said, right here, let's find it. The NCAA's business model, let's say the College Football Commission's business model would be flatly illegal in almost any other industry in America. They cannot, all the restaurants in the region cannot come together to cut cooks' wages on the theory that customers prefer to eat food from a place. And you may go, well, that's because they weren't paying them at all. But again, remember, fair market value. Are the schools coming together to limit what would be the fair market value for that athlete to go there? You could make that argument. And that's why, again, you have this statement, this paragraph, where they say, it sure sounds like yet another instance of competitors, in this case, the power conferences, conspiring to limit athletes' compensation. Go back and read, we just did that, the Supreme Court decision on Alston v. NCAA to see how the highest court in the land feels about restrictions on athletes' compensation. That's what I read to you, right? They don't like it. They didn't like that the NCAA was doing it, so why would they like that the College Football Commission could be potentially limiting student athletes' compensation? That's why I wanted to talk about this, okay? Because that's the important part of this conversation that I feel like too many people, let me go back to full screen here. I feel like there's some people in media who have been a little flippant about some of this stuff, like, the NCAA, for all intents and purposes, I don't know how much longer it's going to last. The College Football Commission will probably get sued the first time it denies a potential payout where the player says, "Hey, I'm worth that much. Why are you telling me that I'm not? That it's below I'm below fair market value?" Again, the school's willing to pay them. What you need to be making sure is that that what's being done is an actual job. I think that's the important part with regards to this. Don't just, you got to be making sure that what they're doing is they're actually doing a job. But yeah, um, here's where it's going, guys. Long story short, we've talked about all this, done all this. The only way out of this for the future is that schools basically have the players become employees. Okay? They become employees. You have to have a collective bargaining agreement. It's how the NFL and the NBA and MLB, they get away with, hey, we're the only professional league. They have this exception because you have a players union, which means you would have to have a college student athletes union to do anything. This is where we're headed. I'm just letting you guys know. This is where, my opinion, we're headed. I could be wrong. I will admit I'm wrong, but just based on the things that I've been reading, especially after this settlement, basically the facts that I've been reading, again, you just saw it with Stuart Mandel writing about it, that he's talked to legal experts. We read out of the Supreme Court. Supreme Court basically says, we do not like you guys restricting how much compensation athletes get. And I know that NIL Go is supposed to be moderating and saying whether or not a deal is fair market value, but who are you to tell these athletes? I'm guaranteeing you, you're going to see lawsuits for the first time they reject it. So that's why I'm saying where we're going towards, where we're headed towards is this is now, it has to be more professional. It has to be more professional sports. All the amateurism, it's all dead. You're going to have to, as a school, make these athletes be employees of your school. You have to have a college athletes players union, and maybe you have to do it for each individual sport. I don't know the correct answer in this regard, but that could be a way to do it. But right now we're going back to kind of trying to do it a certain way, and it's not going to work out. My opinion, college players athletic college athletes union, collective bargaining with the power conferences, with all the colleges. That's what you're going to have to do, where everybody has a collective bargaining on the compensation with regards to NIL, things like that. I know that's not going to be popular. I know people are not going to like that. You could have it. Someone suggested to me, I saw a SJ line coach talking with him. He said you could have it where professional teams basically rent the name. They basically give money to the school. The school doesn't have anything to do with it except that their name is affixed, associated with this particular professional organization. But guys, or you start seeing athletic spots getting cut. You see teams getting, again, we talked about that, roster limits. Maybe some spots are going to get cut. How are the schools going to pay for all of these athletes? How are they going to do the compensation to make it fair, where you have an issue in terms of avoiding Title IX lawsuits and then lawsuits against the commission? They just need to go to the pro style way of doing it. Basically, players union, collective bargaining, and I think that's the only way you're going to do it. Or you really get on the Congress and Senate to make a law or do something for the college sports. But college sports, as we know it, it's not going to be the same. I don't even know if this is going to last a full 10 years. Okay, this whole thing, this program, this $24.5 million, supposed to last for 10 years. College Sports Commission, 10 years. It's supposed to be a way to buy time for the Senate to take care of stuff. I don't know if it's going to make it 10 years. I just showed you that we already had a lawsuit within the first 5 days about the compensation being given to the student athletes in terms of the women. I hate to say it. I think college sports is pretty much dead. We just are waiting for the official thing to happen. I just don't know how you're going to get out of the lawsuits with regards to, constraining players from being able to make as much compensation as possible. Again, Supreme Court didn't like that. That's what got the NCAA in big trouble in 2021. So those are my thoughts. I wanted to talk about it. We spent maybe about 45 minutes with me talking about it. Not that, I don't know if people are in here to ask questions, but I wanted to give you my own thoughts with regards to that. I wanted to talk about it. I wanted to go over that with regards to all of this for you guys so that everybody can really enjoy all of this situation. But the NCAA, it just needs to be prepared to go to the pro style thing. We just need to be prepared. This is now like the G League and all these sports. I don't know what's going to happen. I think it's kind of sad if you see sports being cut out from schools because they're like, we can't pay for these. We're not going to be able to give them enough money. But again, you have the issues with some other things. Anyway, if you're watching this live stream later, or you're watching, I might just make this a VOD. If you're watching the VOD of this live stream, let me know your thoughts down below. And yeah, we will see you next time. I'm going to go ahead and stream right here. I don't think there's anybody in the chat ready to ask a question, and that's okay. So we'll see you next time. I do want to recognize the members of this channel at the booster level and above for their support. If you wish to have your name in a video just like this, make sure to check out the join link in the description below. Here on the end screen, you can see that there's another recommended video. Make sure to click that and watch it. Also, make sure to subscribe so that you don't miss out on any future breakdown videos. I hope you have a great rest of the day.